And in Kaz's case, the hard part about it is that they're also going to group and lump him together with everyone else. In these type of cases, everyone goes to trial at the same time in the same setting, generally speaking. So not only is the jury going to hear the evidence that they have against Kaz, they're going to hear the evidence that they have against everyone else, and he's going to get lumped in with that.
Peace, world. It's the homie Timbo, and we back with an update on the Casanova case. Now we got the InfoMind's legal analyst, Mr. Napoleon Hilton. In February, a judge denied Casanova's request for a $2.5 million bail. The judge reportedly had a concern about Casanova posing a danger to the community. Now, according to an article on Vlad TV, one of the reasons the judge denied him bail was because of an interview he did with Nick Cannon, where he bragged about his street activities. Now, could statements you make on an interview be used against you, be it in a trial or a bail hearing?
Timbo, I tell people all the time, any statement, any post, any interview, any recording, anything that you do can be used against you in court if it's coming out of your own mouth. And I'm not surprised at all. Like I always say, the federal government has all of the resources and they use them. So if you gave an interview, or in this particular case, if Kaz gave an interview suggesting that he was involved in gang activity, the feds are going to use it against them, and a lot of judges accept that.
Now, Hilton, the prosecutors also cited a private text message in which Kaz allegedly says, "I'm under Dick Wolf, the godfather of all apes," which they believe proves his high-ranking role in the criminal organization. Now, how would they have obtained these text messages?
Any electronic communication that is sent over the airwaves can be intercepted. The government has been doing it for the longest. Think about World War II, where the Army intercepted Morse code. Now, 70 years later, imagine the technology that they have. The feds access people's text messages the same way that they access people's personal telephone calls. They get a warrant from the judge to tap your phone, and that phone tap also includes text messages. There's a second way that they sometimes get text messages. Your phone leaves a digital imprint. So every text message that you send, it's actually in your phone's memory, even if you delete it from what you can actually see. And there's technology out there that can retrieve all text messages sent from your phone within a certain amount of time. The federal government either A, got a search warrant for his phone so that they could intercept his text messages, or B, when they arrested him, he had his phone on him and then they did a data dump. Even though your text messages are deleted on your phone, they don't get erased. Just because you can't see them does not mean that they cannot be recovered. And I tell people all the time, you have to be very careful about what you say or what you do over electronic communications.
And the feds also showed text messages in which they say Kaz branded weed called 2 Extra, and that served as a revenue stream for the Gorilla Stone Bloods. The drugs were allegedly trafficked by the gang members. The gang members allegedly paid via the Cash App. Now, would doing drug deals and things of that nature over the Cash App be extremely stupid, as they are basically leaving a trail?
I'm sure Kaz's attorneys are going to argue that, yes, he smoked marijuana, but he didn't receive any proceeds from the marijuana. Now, I would like to believe that they were not going around and putting things on Cash App and putting a message on Cash App saying, hey, this is for the marijuana that was sold. I would like to believe that they're not that stupid. That would be dumb. But short of that, I think that there is an argument. The feds are trying to make a link. I don't know if the link is there or not. I haven't seen the text messages, so it's really hard for me to say.
Now, Kaz has since deleted his Instagram and other social media. Now, will deleting his social media accounts really help him now, or is it too late? And will the feds have already gotten what they needed from his social media account?
Come on, bro, it's the feds. You already know they got it. The technology that they have is unparalleled. Just because you delete your social media accounts does not mean that they cannot have access to it, especially when it comes to places like Facebook and Instagram. All of that creates a digital imprint, and the federal government has the tools to get that information.
Now, can you also remind the viewers what Cass is charged with and the potential sentences associated with those charges?
Cass is charged with racketeering. So therefore, not only is he responsible for the acts that he committed, he could also be held for other acts that was committed by the organization. Now, that's a broad brush, and that's the reason why the RICO and racketeering laws came about. With that, he's facing a significant time in prison, potentially. It's hard to say at this early stage in the game what a likely sentence would be. There are so many different factors. Suffice it to say, he's facing a substantial amount of time in prison if he goes to trial and is found guilty, especially if he's really high up in the organization.
Feds have revealed that they installed a listening device at the Auburn Correctional Facility to eavesdrop on the visits between alleged untouchable Gorilla Stone gang leader Dick Wolf and the alleged members of the gang. Can you tell us, are the feds allowed to install listening devices in prisons and use the evidence gathered in the courtroom?
Yes and yes. The feds quite often use that technique to gather information, and yes, they use that information against the person in the courtroom also. The feds are allowed to record any conversation where a person does not have a reasonable expectation of privacy, and there are several federal courts throughout the country that have held that inmates do not have a reasonable expectation of privacy in their conversations inside of a cell with other individuals. Now, if the feds tried to record a conversation between an inmate and his attorney, there is a recognizable, reasonable expectation of privacy. So the feds would not be able to use that information against a person if they were talking to their attorney. But if they're just talking to a regular person, they can record it. They do record it, and they do use it against individuals in court all the time.
The feds also say they recorded numerous prison call conversations between Casanova and the gang's leader. Do they have the right to tap those phones and eavesdrop on those private conversations?
Absolutely. The first thing that happens when an inmate calls someone on the outside world, there's a recording from the jail that lets you know that these calls are being recorded.
This call is now being recorded.
When they make that announcement, you lose your right to privacy because you are consenting to the fact that those calls are being recorded by continuing to have a conversation. Now, if there were calls between individuals who were not in jail, let's just say, for example, that I called you, neither one of us are in jail, the feds, generally speaking, need a phone tap warrant for that, and they frequently get those for magistrate judges. That is probably one of the most common techniques that the feds use when dealing with RICO or conspiracy cases.
Back on February 12th, the feds unsealed a new superseding indictment, which added 5 new racketeering charges against the gang. Now, what is a superseding indictment? Does this mean Cass may be facing more charges?
You hit the nail on the head. A superseding indictment is exactly what you said. It's additional charges against an individual or individuals in the first indictment, or it could add more people to the indictment. So now they're facing additional charges, and every time that the feds arrest someone or digs deeper, they're going to add everything that they possibly can because this is a high-profile case.
It was also revealed the prosecutors are asking the judge to seize property or contractual rights of any kind. The proceeds obtained directly and indirectly from the racketeering activity alleged in the indictment. This includes any assets that cannot be located, have been transferred, sold to, or deposited with a third person. Can you break down what this means in layman's terms, in plain English?
As far as seizure of property is concerned, what the prosecuting is asking the judge to do is to take the property of the members who were involved in the conspiracy. That could be cars, that could be a home, that could be jewelry. It could be anything that someone bought with proceeds from illegal activity. So the easiest example is if a person is selling drugs and they went out and bought a Mercedes from the proceeds of the drugs, then the federal government can seize the Mercedes that you bought with the proceeds from the drugs. The federal seizure laws are extremely draconian, and it's very, very difficult when a person is placed in those circumstances that not only could they go to jail, but they can also lose everything that they own.
Now, Hilton, with the first indictment, right? And now they got this new indictment, and there's talk of assets being seized, bail denied. From your experience, how does it look for Cass? How bad or good does it look, bro?
Anytime a person is in the federal system, it looks bad for them because the federal government, they do the investigation first, and then they arrest you for things that they believe that they can prove beyond a reasonable doubt. And they have time, energy, and resources to do it. So anybody in the feds, the case always looks somewhat dire. Now, I'm not saying that every case is like that, and I've won federal trials before, but the majority of the cases are extremely difficult, especially when it's investigated by a federal agency for 3 years. They put their resources on the line, and most people in those situations either plea out or go to trial, and a lot of times there's not a favorable result. That's the hard part about federal cases, is that they have time and they have resources, and they investigate and they use the resources that they have to dig into your Facebook profile, to look at your Instagram account, to read your text messages, to listen to your telephone calls, to listen to the jail calls, to listen to who you're talking to while you're in jail. They have unlimited amount of resources, and in high profile cases, they use them. And in Kaz's case, the hard part about it is that they're also going to group and lump him together with everyone else. In these type of cases, everyone goes to trial at the same time in the same setting, generally speaking. So not only is the jury going to hear the evidence that they have against Kaz, they're going to hear the evidence that they have against everyone else, and he's going to get lumped in with that. And those are high hurdles to overcome in these type of cases.